Hello everyone, welcome back to the channel Legalese. Today we will be discussing or continuing our discussion on Place of Suing. We will be starting with the section 17. So till now under 15 and 16 we have seen that we should go to the lowest court jurisdiction, court of lowest jurisdiction, as well as we have also seen that in case of immovable property the jurisdiction of that court will be there where the property is situated and where the defendant resides, carries on business, or personally works for gain if the relief can be sought entirely through his personal obedience. Moving ahead to section 17, it deals with the case wherein two or more court has the jurisdiction over one immovable property. Then in those cases, all the courts that has the jurisdiction will be the court of jurisdiction and the plaintiff will have a choice to file a suit in any of the court, provided that the court that has the jurisdiction should have not only the territorial jurisdiction but also the subject matter and pecuniary jurisdiction. For example, let's suppose there is a this is a property and it comes within the jurisdiction of these three court. This is code A, this is code B, and this is code C. Okay, so these are the three codes that cover the property. Now, the portion of the property is different for all these codes, but the plaintiff in relation to this particular property can file a suit in either of the code A, B, or C. However, let's suppose the particular suit involves an amount of 10 lakh rupees and this particular court has a jurisdiction of 10 lakh. This court has a jurisdiction of 20 lakh and this court has a jurisdiction, pecuniary jurisdiction of 5 lakh. So in this case, the plaintiff will have an option of filing a suit either in the B court or in the C court. A court will not have the jurisdiction. So all the courts will have it, but they should have the other jurisdictions as well. That is what is given under section 17 and nothing else. Moving to section 18. Section 18 talk about a case when there is no specific court which has the jurisdiction, so it is uncertain which court will have the jurisdiction. So it is said that if a particular property, again, let's say uh, these are the codes. Wait. Okay, code A, code B, and code C. Okay, this is code A, this is code B, and this is code C. Now a property is situated in this part. Okay, and this part do not come under the jurisdiction of any of these court. So in such a situation, if this is the property, this shaded part, then this particular property will go to the court which is adjacent to it. So any court can have a jurisdiction which is closer to this particular property, provided that if let's suppose you are going to this particular court, then sorry, if if you are going to court A, then you will be asking or requesting the court A to determine whether there is an uncertainty or not. This court A will write a statement that there is some kind of uncertainty related to the jurisdiction of the property, and that's why this particular court is taking up the jurisdiction. When this court note down such a statement and to take the jurisdiction of the property, then it will be assumed that this particular property belongs to the or come within the jurisdiction of court A. Similarly, if you are going to code C and code C write down this, then also it is possible. Same for code B. So you can go to the any of the code, and these code can write down a statement that there is an uncertainty regarding the jurisdiction of the property, and therefore they are taking the jurisdiction of the property. In this case, again, all the courts should have other jurisdictions like subject matter and pecuniary jurisdiction should be there. So again, if this court, the property value is 10 lakh and this court is having jurisdiction of 5 lakh, this having 10 lakh and this having 20 lakh, then in those cases, you can go only to code B and code C and they will write down a statement related to the uncertainty and then they can take up the jurisdiction and it will be assumed that the decision is correct. Now, it says, so this is the main body which says that whenever there is uncertainty, then in between two or more of the courts, then the court has to record a statement about that uncertainty and then proceed to entertain and dispose of the suit. And if a decree is passed, it shall have the same effect as if the property was situated within the local limits of its jurisdiction. Like I said, that a legal fiction will be created that the court had the jurisdiction, provided it should have the other jurisdiction subject matter peculiar. Now, this particular provision is important. It says that let's suppose a court does not have a jurisdiction, and then also you file a. So, in this particular case, let's say there was no uncertainty or no statement was recorded related to uncertainty. You approached Court B, and Court B took the cognizance of this particular property, but later on, it was the opposite parties felt that there was no uncertainty. This particular property was coming within the jurisdiction of Court C, and therefore Court B did not have the jurisdiction to try it, or Court B did not write the statement that there is some uncertainty. That's why they are taking up the matter. So when the defendant or basically the judgment debtor will go for an appeal, then in those cases, in the appeal, or if you have filed a revision, then both revisional court or the appellate court, the court will see whether there was uncertainty or not. ठीक है, सबसे पहले तो कोर्ट विल चेक कि वहां पे अनसर्टेनिटी का ग्राउंड है या नहीं. अगर है तो फिर obviously the court will say that even if they have not recorded the statement, the decree is valid. But if the court find out that there was no uncertainty, then in addition to the uncertainty, they will check whether there is a subsequent failure of justice. If there is failure of justice along with no non-existence of uncertainty, then only the decree can be challenged and can be set aside by the appellate court or the revisional court. Otherwise, the decision of the court B will be valid even if there is no uncertainty. So, along with no uncertainty, you have to prove that there was consequent failure of justice for the parties, and then only the decree will be set aside. So that is what is given, that the appellate court shall not allow the objection unless, in its opinion, at the time of the institution suit, no reasonable ground of uncertainty was there, and यहाँ पे they have not used the term or, they have used the term and. So after first uncertainty will be shown that there was no ground of uncertainty and consequent failure of justice. If you are not able to prove any of the ground, then you will not be allowed to challenge the appellate or the revisional stage. Coming to section 19, section 19 is very easy and to the point. It talk about jurisdiction in case of movable property or cause of action. So it says that the jurisdiction of the court will be decided on the basis of the place of residence of the defendant or the place where he carries on business or personally works for gain. जो हमने section 16 में भी पढ़ा था इससे पहले वाली मीटिंग में कि इन तीनों में से आप कोई सी जगह देखोगे और उस जगह पे jurisdiction होगी. इन तीनों में से आप कोई सी भी जगह पे plaintiff suit file कर सकते हैं. Suppose plaintiff lives in Nagpur, defendant also lives in Nagpur, but defendant carries on business in Mumbai, and defendants work for or carries on business or work for gain in Mumbai. So the plaintiff will have an option of filing the suit either in Nagpur or in Mumbai. Also, if the cause of action has happened in another place, let's suppose cause of action occurred in Delhi, then the plaintiff will have an option of filing a suit either in Nagpur or in Delhi or in Mumbai. Similarly, यहाँ पे अगर रेजिडेंस की जगह डिफेंडेंट का बिजनेस नागपुर में होता और रेजिडेंस मुंबई में होता, तब भी it will not have changed the situation. The plaintiff will have an option of either the place where the cause of action arose, or the place of residence of the defendant, or the place where the defendant is carrying on business or personally working for gain. 20 is also called, and it is very important provision, it is also called as the residuary provision. Okay, so first of all, let us understand the meaning of section 20. यहाँ पे इसको residuary बोलते हैं. Residuary इसको इसलिए बोला जाता है because the language of this particular section starts with subject to the limitations aforesaid. So when they are saying subject to the limitations aforesaid, means subject to the limitation mentioned from section 15 to 19. So 15 to 19 sections have more value or more importance as compared to section 20. So they will be preferred over section 20. If these are not applicable, then only you will apply section 20. So it says the three types of situation or three types of jurisdiction are talked about in it. I'll explain it via illustrations, and then we will go through the provision. So let's suppose the example that I gave you, I'll repeat this particular example in a different way. It is similar to the illustration that is given. A, B, C, and D are three people. They went together or at different time to Varanasi. Okay. Now A is a resident of Nagpur. B, C, and D, they all three resides. Let's suppose B resides in B resides in Nagpur but carries on business in Delhi. Okay. C resides in Delhi but carries on business in Mumbai. D resides in Delhi and carries on business in Kolkata. Okay. Now it says first subsection of section 20 says that you can file suit either where the cause of action is arisen or where the defendant, when there are more than one defendant, all of them resides, carries on business, or personally work for gain together. So in these three defendant, Delhi is the common place. So either at Varanasi or at Delhi, the suit can be filed by this person A. But he cannot go to Nagpur because he only one defendant has a residence in Nagpur and the other defendants do not have. But subsection 2 says that if there are all the defendants live and carries on business at different places, then what will be the situation? Again, let's take an example. A lives in Jaipur, B lives in Jodhpur, and he carries on business in Bhopal. Okay? C, uh, C lives in Delhi and carries on business in Mumbai. D lives in Kolkata and carries on business in Chennai. Now the places for all these people are different, and let's suppose they all went to Varanasi and there they entered into a contract which was breached by B, C, and D, and A want to file a suit. So now, first of all, he can file the suit in Varanasi because the cause of action arose in Varanasi. They entered into a contract and breach happened in Varanasi. In addition to that, since there are more than one defendant, he can file the suit in any of the place of residence, place of business or personal work from gain of the defendant, but he has to take permission of the other defendants who do not have their residence place or working place or business place in that particular area or leave of the court. For example, if A want to file a suit in Jodhpur, he will have to take consent from DNC that whether he can file a suit in Jodhpur or not. If both of them give consent, then he can file it in Jodhpur. But if both of them do not give consent, then he can take the leave of the court. He can take permission of court. If the court, Jodhpur court also gives him the permission, then also he can file in Jodhpur. But if neither the court nor the two other defendants give him the permission, he cannot file it in Jodhpur. He can file only in Varanasi. Similarly, for Bhopal, Delhi, Mumbai, Kolkata, Chennai, he can either take the leave of the court or can take the permission of the other two defendants and can file the suit there. Otherwise, in Varanasi, he does not need to take the consent of anyone and can file the suit in Varanasi. So this is it, what is given under section 20. So both these sections talk about this, and the third subsection talks about cause of action. It says the cause of action wherever it rises, that particular place will also have the jurisdiction. The explanation says that a corporation will be considered as the place of business of a corporation will be that place where it has a principal office. But if it has more than one office and cause of action arose in any subordinate office, then that place where the subordinate office is situated, that place will also have a jurisdiction. For example, a company has place of business in Mumbai, Kolkata, and Chennai. Principal office is in Mumbai, but subordinate offices are in Kolkata and Chennai as well. And the contract occurred in Kolkata and breach also happened in Kolkata, then even the Kolkata port will be the place of business for this particular company and not Mumbai, because Mumbai is principal, but for other matter, the subordinate office, wherever the cause of action arose, will also have the jurisdiction. But if cause of action arose in Kolkata or Calcutta, then in those cases, Chennai court will not have the jurisdiction because that is only a subordinate office where cause of action also did not arise. So this is it related to section 20 as well. The very important case related to this is New Moga Transport Company. You can read this case to understand all these things in detail, how the jurisdiction is decided. Also, you can refer to the illustrations that are mentioned within this particular section. So please read all these things, and in case of any doubt, you can always comment on it. Please like my channel, subscribe, and see you with the next video related to the objection of jurisdiction. Till then, thank you. Bye bye. Take care.